Hello and welcome back to our channel. If you are on the path to making the UK your permanent home or are dreaming of becoming a British citizen, then this video is one you absolutely cannot afford to miss. The UK's immigration landscape is constantly evolving, and 2025 is shaping up to be a year of some of the most significant changes we've seen in a long time. Staying informed is not just advisable, it's crucial for the success of your application. That's why today we're breaking down 5 major new rules for indefinite leave to remain ILR and British citizenship that everyone must know in 2025. We'll be delving into the details, explaining what these changes mean for you, and offering some practical advice. So grab a cup of tea and let's get started. Rule 1, the potential doubling of the ILR qualifying period first on our list is a potential game changer for many on the route to settlement. The UK government has proposed a significant increase in the standard qualifying period for indefinite leave to remain, more commonly known as ILR. For many visa categories, the current requirement is 5 years of continuous lawful residence in the UK. However, under the new proposals, this could be extended to 10 years. This means that for many individuals on work visas, for example, the journey to permanent residency could become twice as long. The government's rationale behind this is to ensure that migrants have established deeper ties and made a more substantial contribution to the UK before being granted permanent settlement. Now, it's important to note that this is part of the government white paper, which means the proposals are not yet law and could be subject to change. However, the direction of travel is clear. The government is also exploring a concept of earned settlement. This could potentially allow some individuals to qualify for ILR in less than 10 years based on a points system that would reward contributions to the UK's economy and society. Factors that might be considered include working in priority sectors, paying higher taxes, and community involvement. So, what does this mean for you? If you are early in your visa journey, it would be wise to keep a close eye on these developments. If these changes are implemented, you may need to plan for a much longer period of temporary residence before you can apply for ILR. This could have implications for your long-term financial planning, career choices, and family life. Rule 2, a stricter good character requirement for British citizenship. Our second point is a confirmed change that is already coming to effect in February 2025. And it significantly tightens the good character requirement for those applying for British citizenship. This is a crucial hurdle in the final step of becoming a British citizen, and the Home Office has become much more stringent in its assessment. The updated guidance states that anyone who has entered the UK illegally will normally be refused British citizenship, regardless of how much time has passed since the illegal entry took place. Previously, a 10-year disregard period was often applied for such immigration breaches. This is no longer the case. The new rules also specifically target those who have made a dangerous journey to the UK, such as crossing the channel in a small boat or being concealed in a vehicle. An application from someone who arrived in this manner will also normally be refused. It's important to understand the word normally in this context. It suggests that there may be exceptional circumstances where an application could still be granted, but these are expected to be very rare. The change will have a significant impact on many refugees who have been granted protection in the UK, but may have had no choice but to enter the country through irregular means. What's the key takeaway here? If you are considering applying for British citizenship and have any history of illegal entry or a dangerous journey into the UK, it is absolutely vital that you seek professional legal advice before submitting your application. The landscape for this requirement has fundamentally changed, and a refusal can be both costly and detrimental to your future immigration status. Rule 3, soaring salary thresholds for skilled workers and ILR. This next rule is a big one for anyone on a skilled worker visa or aspiring to come to the UK on this route. From July 22, 2025, the general minimum salary threshold for new skilled worker visa applicants is increasing significantly to £41, 700 per year. This is a substantial jump from the previous threshold. This increase will also affect those applying for indefinite leave to remain on the skilled worker route. When you apply for ILR, you will need to show that your salary meets the new, higher threshold but is in place at that time. This means that even if you were granted your initial visa on a lower salary, you will need to have received a significant pay rise by the time you are eligible for settlement. There are still some salary discounts available for those with a relevant PhD or a job on the immigration salary list, but these discounted thresholds have also seen an increase. It is also important to note that the health and care worker visa route has some different salary requirements, but new applications for care workers from overseas are no longer being accepted from 2025. What should you be doing in light of this? If you are a skilled worker, you need to have a clear conversation with your employer about your salary progression to ensure you will meet the ILR requirements when the time comes. For employers, this means factoring these higher salary costs into your recruitment and retention strategies for overseas talent. Rule 4. A revamped life in the UK test and higher English language standards for years. The life in the UK test has been a mandatory step for both ILR and citizenship applicants, often criticised for being a pub quiz on British history and culture. Well, big changes are on the horizon. The government is planning to replace the current test with a new British values test. The focus of this new test is expected to shift away from memorising historical dates and facts and more towards demonstrating an understanding of the UK's core values such as democracy, the rule of law, individual liberty and tolerance. While the exact format and content of the new test are yet to be finalised, the intention is to create a more meaningful assessment of an applicant's integration into British society. In addition to the new test, the government also plans to raise the bar for English language requirements for both settlement and citizenship. The specific levels are still under review, but it's likely that future applicants will need to demonstrate a higher level of English proficiency. The requirement for all adult dependents of workers and students to have a basic level of English is also being introduced. Our advice? If you are nearing your eligibility for ILR or citizenship, it might be wise to take the current life in the UK test and your English language test sooner rather than later, before these new, potentially more challenging requirements are introduced. For those with more time, keep a close watch for official announcements on the new test and language levels. Rule 5. Raising the bar for skilled worker visas. Our final point is another significant change to the skilled worker route. The minimum skill level required for a sponsored job is being raised from RQF Level 3, which is equivalent to A levels, to RQF Level 6, which is degree level. This is a substantial change that will make a large number of jobs that were previously eligible for sponsorship no longer so. Roles in sectors such as hospitality and retail, which may have previously met the RQF Level 3 requirement, will now likely be excluded. This move is part of the government's wider strategy to focus on attracting highly skilled talent to the UK. For individuals already in the UK on a skilled worker visa in a role below RQF Level 6, there are transitional arrangements that may allow you to extend your visa or apply for ILR. However, for new applicants from outside the UK, the door to many medium-skilled jobs is closing. What does this mean for prospective applicants and employers? Prospective applicants will need to ensure that the job they are being offered meets this new, higher skill level. Employers, particularly in sectors that have relied on sponsoring workers for medium-skilled roles, will need to revise their recruitment strategies and potentially invest more in training the domestic workforce. So there you have it, 5 major changes to UK ILR and British citizenship rules that are set to have a big impact in 2025. From a potentially longer road to settlement to stricter character and skill requirements, the message from the UK government is clear. The bar for permanent residence and citizenship is being raised. Navigating these changes can be daunting, and the stakes are incredibly high. Our aim today was to give you a clear and comprehensive overview to help you prepare. We always recommend seeking professional immigration advice tailored to your specific circumstances. If you found this video helpful, please give it a thumbs up, subscribe to our channel, and hit that notification bell so you don't miss our future updates on UK immigration. And please share your thoughts and questions in the comments below. We'll do our best to point you in the right direction. Thanks for watching, and we wish you the very best on your journey to making the UK your home.